All right, everyone. So today we pick up for chapter 3 of the Civil Liberties and Civil Rights lecture. And we left off yesterday at this kind of assortment slide of various memes and pictures. And I'm just going to begin there for continuity's sake. But let's move on to the next question. We are specifically looking at civil liberties as expressed and given in the Bill of Rights. And if you remember, civil liberties are protections in the Constitution from our own government, protections against overreach by our government. So we're kind of going through, we started on the First Amendment in episode 2. And in episode 3, we're going to pick up at the second half of the religious implications in the First Amendment. The first was the Establishment Clause, which is the government cannot favor or establish any sort of official religion or involve itself in religion really in any way. And so the second half, in addition to the Establishment Clause, is something called the Free Exercise Clause. And the Free Exercise Clause, quite simply, is that citizens of the United States have the right to freely exercise their religion as they see fit, right? That they can worship how they want or not worship how they want. And essentially, what this is saying is that the government, the federal government, it cannot be in the business of telling people what they must believe or not to believe. That people have the right to do so as they please. That you can exercise your religious beliefs how uh, how it makes sense to you. And so, what we want to look at, and this is what I want to be really clear at, is that the words of this are fairly simple, but the implications of this are staggering and have taken 150 years of constitutional challenges to kind of build out exactly what are the limits. If I tell someone you have the right to believe whatever you want and practice your religion however you want, what if your religion believes in human sacrifice? What if it believes in polygamy? What if it believes in female circumcision? What if it believes in doing peyote and wandering into the desert so you can have a hallucinatory experience and bring you closer to the Spirit Lord, right? Are there limits? And so the answer to that question is quite simply yes, there are limits. That you have the right to exercise your religion as you like and believe what you like, but the courts have generally been more cautious about how you practice them, right? And so the question here is what to what degree are you allowed to practice your religion? I just gave you a bunch of scenarios that we as a society and that the courts have looked at and generally said, we're not so sure about that, right? Can I, if I have a 4-year-old that has cancer and that is readily treatable by modern medicine, but I don't believe in medical intervention, can I deny my 4-year-old medical treatment and instead just pray the cancer away? Well, the answer is no. Can I refuse to educate my children because I believe, that the only education they need is in Sharia law for Islam or Christian law is like some of the Amish sects? The answer is no. What about polygamy, plural marriage, multiple wives? Right? The answer is no. Drug use? Sometimes. It depends, right? Like Native American tribes can make greater claim to that, but if I want to found my own religion because I happen to really like doing methamphetamine and my religion says that use brings me closer to my spaghetti monster god, the answer is going to be no. Female genital mutilation, right, in this country is illegal, even while it's legal in others. So the courts have spent a long time saying yes, no, yes, yes, no, no, right? And so we have much greater clarity in 2020 about what exactly the free exercise clause allows us to do. And essentially what you come down to is that the government has decided that laws cannot specifically interfere with religious practices unless clear standards are met. So the government can say no to something as long as that practice is in violation of these clear standards. First, the law has to be very, very narrowly tailored, right? Like it has to say specifically You can't use methamphetamine even in religious practices. You cannot simply say you cannot use any controlled substances. That would be too broad. And Native American groups would push back and say we've been using peyote, which is a certain flower on a cactus that grows in the Sonoran Desert. We've been using that for 3,000 years, and they've had rights. So it has to be very narrowly tailored in the language. It also has to be the threshold that the courts have realized is that if the government is going to say no to something and say, I'm sorry, that's far enough, then it must be the government must be able to argue that there is a clear and compelling public interest in restricting that practice. The easiest way to see that would be there is a clear and compelling public interest that says human sacrifice or cannibalism is not allowable, right? If that suddenly became a thing and people started claiming, well, in my religion, we can, barge into my neighbor's house at midnight and sacrifice them to Cthulhu, right? Then the answer to that would be like, yeah, well, society would break down. So you can ban that. But compelling interest must be served, and you must be able to argue that in a court, and the language must be very specifically tailored. So moving along in the First Amendment, outside of just the religious statutes, I now want to look at freedom of expression. So we have freedom of religion, freedom of expression, freedom of association, freedom of press. Let's look at freedom of expression. What forms of expression are protected by the First Amendment? And essentially what we're looking at, the question is, can the government censor speech that it thinks will violate the law? Now, that is a question that you should be somewhat familiar with because I gave you a do now about this just the other day, right? When we were looking at the issue of Near v. Minnesota, right? And I said to you that the issue of prior restraint, can the government stop you from saying something before you actually say it because it thinks that those words or whatever you're about to say is going to be harmful? And essentially what Near v. Minnesota did, and again, these are good stories that I would love to tell you if we had real time, but maybe are boring more in this, is Near v. Minnesota was a newspaper published some things about elected officials being associated with the mafia. And the elected officials in the state sued that publication and said, we're going to stop you from printing these newspapers before you even release them. So we're going to barge in, take over your printing press so that you cannot release these articles which we feel are slanderous. Well, the newspaper sued and the court said, we side with the newspaper. The government cannot rule against actions or cannot use prior restraint, cannot stop you from saying something before you actually say it, unless clear and compelling interest can be served. Now, this is not applicable in schools, and you're going to hear that from me a lot. In general, the courts have allowed schools to limit First Amendment freedoms at much greater, length than other parts of society. And the argument there is that, well, if we allowed freedom of, association or freedom of assembly in schools, then basically nothing would get done. And they said, yeah, we buy that. So prior restraint is allowable in schools. We could stop a school paper from saying something. And the other exception is when you can limit somebody and use prior restraint to stop them from even speaking in the first place would be for clear and compelling national security reasons. Right? And so if I barge in and I seize Edward Snowden before he could leak all those documents to WikiLeaks about government wiretapping, the government must be able to argue in court that the release of those documents by Edward Snowden would constitute a clear national security problem. If that argument is accepted by the courts, then prior restraint is upheld. But in general, prior restraint is not. Now, the kind of the threshold or the exception to this, right, was established in that case you looked at the other day, which was Schenck v. U.S. 1919, right? This guy in New York comes along arguing for the violent overthrow of the United States, and the government basically locks him up and charges him with sedition before he could even really start to release these materials. And in that case, the government said, yes, we can do that, right? Because that is a clear and present danger. And that clear and present danger test is words that you're going to hear probably in your lifetime. You can limit somebody's speech if there is a clear and present danger from their speech. The easiest to understand scenario there would be, can you yell fire in a crowded theater, right? If you did, there would be a stampede to the door. People could be injured and even killed as people tried to desperately get out of the theater. And you can't then argue after the fact that, well, I was just, exercising my free speech, right? That's a clear and present danger test that would fail. And so I could censor your speech, or I could use prior restraint if I knew you were going to do that, right? Now, here's where the law gets interesting, right? And this is where I want you to see the law is fluid, constantly changing, and builds on itself. If we said that Shank the United States was limiting speech prior to being said, right, because you were arguing for the violent overthrow of the US government and you were specific, then yes, you could stop somebody from saying. But the courts have generally been okay with somebody like arguing for the overthrow of the US government as long as they do it in the abstract. Meaning, they're not saying, tomorrow on Tuesday, meet me at 8 a.m. here, bring this, this, and this, and we're going to rise up and overthrow the government. That would be against the law. But if you just, if I go on YouTube later tonight and record a video of me saying, down with the United States, I hope it burns and falls apart, that's far more abstract, and so that would be allowable. Now, what about the right to protest in public places? Public places belong to us, the public, streets and parks and our cities. And the right to protest and advocate is guaranteed in the First Amendment under the freedom of assembly. But obviously, if 100 people wanted to lock arms on I-25 during rush hour and then argue that they have the right to assembly, that right would not be upheld. So there are limits, and I hope you're starting to see this. The Constitution guarantees us civil liberties, but it has been up to the courts over many, hundreds, 150 years to kind of say exactly how far. And so continuing on, let's talk a little bit about what kind of actions are speech and deserve constitutional protection and what doesn't, right? So for example, my words coming out of my mouth is clearly speech. What if I write something on the internet? Is that speech? Well, the courts have generally said yes. What about if I don't really say something, but I wear, an armband on my sleeve that everybody knows is symbolic of, somebody who's advocating for, child molestation? Is that protected speech? Is that speech even? It's just an armband. And so let's look at what the courts have said. What forms of speech or expression are protected? First, I have to tell you a little bit about the case of Roth v. U.S. Now, without getting into the ins and outs of Roth v. U.S., essentially what the decision and the opinion written by the court in Roth v. U.S. said was that obscenity is not protected speech. Meaning, if I, in public place in downtown Colorado Springs, open up a storefront and I call that storefront, nothing but a series of profanity filled with the F words, and that's the title of the store, am I allowed to? And the decision in Roth v. U.S. essentially said, establish a litmus test. And the litmus test for obscenity as protected speech would be, well, if you ask the average citizen in that time and place whether this was obscene, and they said yes, then that is not protected speech. But the court also knows that there are lots of people out there that are very sensitive, and maybe you are a very conservative Christian, and so you think the word damn, right, or ass is incredibly offensive. And the court has largely said, well, the common person doesn't believe that those two words are offensive, so therefore we allow it, right? But, pornography on a street corner would not be. We're going to end there.